नमस्कार दोस्तों, आपका स्वागत है योगेश महाजन लीगल चैनल पर। योगेश महाजन लीगल चैनल पर हम आपको प्रस्तुत करेंगे नवीनतम सुप्रीम कोर्ट के फैसलों और विभिन्न अन्य न्यायालयों के फैसलों पर और विधि ज्ञान को प्रसारित करने का प्रयास करेंगे। इस चैनल पर हम न्यायिक फैसलों के महत्व को समझाने और विधि समझौतों की युक्तियों को समझाने का प्रयास करते हैं। हमारा मकसद है कानून और न्याय के क्षेत्र में ज्ञान को आपके पास पहुंचाना, तो कृपया हमारे चैनल को सब्सक्राइब करें, घंटी आइकन दबाएं, वीडियो को लाइक और शेयर करें।
24th of January 2024, the Honorable Supreme Court has pronounced another judgment. It's related to a divorce case. Here, in this case, the appellant is a husband and the respondent is a wife. And a husband has filed a case before the family court in which the husband petition for the divorce get dismissed, and thereafter he moved before this Honorable High Court, and before the Honorable High Court the order of the family court get upheld, and as a result his petition first appeal also get dismissed. Thereafter he files a special leave petition before this Honorable Supreme Court. The facts of the case were that both the husband and wife, they were married and they have the child, and both were settled in the Canada. Thereafter, due to the recession, husband lost his job. Then as a result, they both came to India. A wife stays with the husband for a couple of days. Thereafter, she started living in the parental house. Thereafter, husband requested many times that the wife should join him, but the wife did not accede to his request. Thereafter, wife left with his child to the Canada. Husband has also filed first a restitution case. Husband has filed a restitution case. Thereafter, he withdraw that case, and then he filed a divorce case on the grounds of cruelty and desertion. Family court rejected his petition and held there was no cruelty from the side of the wife. High Court too has upheld this order. Thereafter, he approached before this Honorable Supreme Court. Let's see what's the contents of this judgment. We will try to find out the legal principles involved here in this judgment. This is an appeal against the judgment and impinged order. This was passed by this Honorable High Court of Judicature at Bombay at Family Court. Means the husband has challenged the order that is 24th of June 2021, and Family Court Appeal number so and so, and this Family Court order was upheld, and his appeal got dismissed by the Honorable High Court of Bombay. So facts of the case were that both appellant and the husband their marriage was solemnized on 5th of Hindu religions after spending 8 years in the courtships, and they were the Indian citizens by the birth, and they acquired citizenship of Canada for financial gain, and they were living a normal and happy matrimonial life in Canada. So during the wedlock, the male child was born on 21st of May 2010, and in the year 2011, the appellant, who is the husband, started experiencing medical problems such as the constant back and shoulder pain, and as well as the skin related to the problems, especially during the summer due to ragweed allergy, resulting into the sleepless nights and miserable days. So during the recession period, the appellant lost his job, and couple along with the minor child returned to India on 29th of January 2011. The respondent, who is the wife, willfully stayed at the matrimonial home, and thereafter joined her parental home on 20th of February 2011. Means almost 2022 days she separated from the husband and started living in the parental house. After some time, the appellant asked the respondent to come to resume cohabitation. The respondent did not pay any heed and refused to join the company of the appellant. So the respondent was interested in returning to Canada for a better future. Means the wife was interested that the husband should go along with her to Canada for a better future. But the appellant, however, shows the unwillingness, expressed his unwillingness to shift to Canada due to the health issues. It means the fact says, as per the facts, that the husband, due to the medical problems, came back to India, but the wife stayed there with the husband almost 20 to 22 days at the matrimonial house. Then she started living at the parental house. Husband requested the wife that she should join him. But the wife did not paid any heed to his request. But as she was interested, that the husband should go along with her to the Canada. The respondent left to Canada with her son. The appellant tried to contact the respondent through emails and requested her that she should join back her, but there was no response from her side. And then the appellant filed a case under Section 9 of Hindu Marriage Act for restitution of the conjugal rights. So those who are laymen, they should know that under the Hindu Marriage Act, any spouse can file a case against the other spouse who refuses to join the applicant spouse. The applicant spouse has the right that he or she should approach to the court for resumption of their conjugal rights. So her husband has adopted this legal remedy, but the appellant the notices were issued and respondent were duly served, but thereafter appellant withdrew the petition for restitution of conjugal rights, because since the appellant realized that there is no hope for the restitution, hence he files a divorce petition on the grounds of cruelty and desertion. Cruelty and desertion application can be filed under Section 13, Subpart 1, Subpart 1 IA and IB under the Hindu Marriage Act. Any spouse can file the case on these grounds. The petition proceeded as ex parte, and despite due services, respondent remains unrepresented. So means notices were issued, respondent did not contest the case, so the respondent were treated an ex parte. But after considering the pleadings and evidence, the learned family court dismissed the petition for the appellant. It means even the wife did not contest the application, but the family court, after considering the materials available on records, it means the petition and his evidences, the court found that it's not a fit case that he should be granted divorce on these grounds. Alleged cruelty caused by because as per the court that respondent appellant fails to prove his cruelty, so they dismissed their petition. And now when the order came, then the husband aggrieved and dissatisfied by the dismissal of the petition by the learned family court, the appellant files family court appeal before the High Court. And the High Court dismissed the appeal by holding no case has been made out of appellant for seeking a decree of divorce on the grounds of cruelty or desertion. Thereafter, our husband adopted the last remedy. That means he challenged the order of the High Court before the Honorable Supreme Court of India, and the notices were issued. Considering the facts and the circumstances, the court framed the question. The short question arises for consideration whether decree of divorce can be granted for the reasons that the marriage has been irretrievable broke down. This is a question of law which has been framed by the Honorable Supreme Court, whether the marriage has irretrievably breakdown. Notices were issued to the respondent, but respondent again did not put her appearance either in person or through an advocate. Now it's only the husband has to prove the legal question. He has to prove his case before the Honorable Supreme Court of India. The court heard the counsel who was appearing on the behalf of the appellant, and the counsel had made a submissions that respondent deserted the appellant for about 13 years ago, and she refused to cohabit with the appellant. Learned counsel further submit that the appellant and respondent have been living apart due to the marital discord for 13 years, and there is no prospect for the reconciliations, and the marriage has been irretrievably broken down. So this is the arguments which were placed by the the counsel on this counsel from the side of the appellant husband, and it says that nearly 13 years has already been passed. There is no scope for resumption of the marriages. Notices are also issued, and the council also argued that uncontroverted evidence is substantially established that the facts that the appellant has treated with mental cruelty by his wife means since husband he is the only person who has led his evidences, and there was no scope for the cross examination as the wife did not tender her opinions either in person or through an advocate. The councils made a submissions. It was an uncontroverted evidence, who left the company despite an objection from the appellant. The land council further submitted that the conduct of the respondent itself indicates that she is not willing to live with the respondent, and in support to this, he relied upon certain judgments: Sukhdev Das versus Rita Mukherjee and Samar Ghosh versus Jaya Ghosh. These are the two judgments which were relied by the council of the appellant. And now May Court has made their own observation. The court, after pursuing the records, the court found that record reveals that appellant car accident took place on November 2009, and they were blessed with a baby boy. The appellant lost his job due to the deep recession in Canada, and the family came back in India in January 2011. The couple resided together at appellant's mother house in Mumbai till 19th of February 2011. After this day they lost the contact with each other, and respondent refused to return to the matrimonial house. On being contacted, respondent refused to resume the matrimonial life unless the appellant separates from his family and resides in the same household. This was the condition made by the respondent wife, that husband should leave the company of his mother and should live separately. But the appellant's inability to accede to a demand of respondent, she never returned to resume the matrimonial life. And it has also been seen that the proceeding initiated by the appellant for restitution cautionary rights, respondent did not appear despite receiving summons. Similar in the present divorce petition, the court has saw the previous litigations which were filed from the side of the husband. The court found that even when the husband has filed the restitution case, the wife did not contest her case, and neither she has appeared in person nor she has engaged any advocate. And similarly, as far as the divorce case is concerned, the wife did not appear and contested the case. So, but the petition was dismissed on the grounds of the merits. Now, court has the court relied upon the judgments which were. And in the matter of the Shilpa Shailesh versus Varun Srinivasan, this is the judgment. The court relied upon this judgment, and they found that court has held that the exercise of jurisdiction under Article 142 Constitution is clearly permissible to do a complete justice of the cause of matter. The court can pass any order or decree on which a family court, trial court, or high court can pass. And when such power is exercised, the question or issue of the lack of such subject matter jurisdiction does not arise. So the court says that in this judgment, the court has relied upon these contents, and that judgment the court held that Article 142 is the power which is available only to the Supreme Court, and court has the inherent powers to issue directions, and the question of the issue of the subject matter jurisdiction does not arise. Means court can issue any direction under Article 142 and of the Constitution of India. And on the grounds of the irretrievable breakdown of the marriage under Article 142 of the Constitution, the court in Shilpa Shailesh judgment held in para number 33 and 34. These were the paragraphs which were quoted by the Honorable Supreme Court of India. Important. This is the. And then now these principles apply here in this case too. Reverting back in the case in hand, the court the satisfaction whether the present case is fit for exercise of power under Article 142 of the Constitution of India to dissolve the marriage on the grounds of irreversible breakdown. We see the parties. Now court says whether the Article 142 of the Part 1 of the Constitution of India, the court can apply this power or not. The court applies their principles which were laid down in the previous judgment, and then comes into the facts of this case that since the parties were living separately for almost 13 years and there was no contact between them during this long period, the respondent wife is not even responding to the summons issued by the courts. It seems that court held that she is no longer interested in continuing the marital relationships with the appellant. And the court made their observations that for the long period, for 13 years, she was almost zero contact with the petitioner, with the appellant, and court has also issued summons. She has not even bothered to respect them. She has not bothered to follow the means to comply the summons, and the court finally held. We have no hesitation in holding that the present case is a case of the irretrievable breakdown of the marriage, as there is no possibility of the couple staying together. The court finds that this is a case fit. This case is a fit that the principles of Article 142 of the Constitution can be applied here in this case. This is a fit case that court can grant divorce on the grounds of irretrievable breakdown of the marriage. From the foregoing reasons, the appeal is allowed and dissolve the marriage between the parties on the ground of irretrievable breakdown of marriage in the exercise of the powers under Article 142 of the Constitution of India. Accordingly, the marriage between the parties, which was solemnized on 5th of January 2004, is dissolved by a decree of the divorce. A decree to this effect is drawn accordingly. Finally, court has granted the relief to the appellant. The court held that this is a fit case, that the powers given to the Honorable Supreme Court of India under Article 142, Subpart 1 of the Constitution of India can be applied here. So, the court has granted a decree of divorce and give the relief to the appellant husband. And this was a judgment which was passed on January 24, 2024.
उम्मीद है कि यह वीडियो आपको पसंद आया होगा। अगर आपने अभी तक हमारे चैनल को सब्सक्राइब नहीं किया है तो कृपया इसे सब्सक्राइब कर ले और बेल आइकन दबाकर नोटिफिकेशन प्राप्त करें ताकि आप हमारे नए वीडियो से अपडेट रह सकें। अगर आपको यह वीडियो पसंद आया हो तो कृपया लाइक करें और अपने दोस्तों के साथ शेयर करें। हमारे चैनल पर आपको न्यायिक मुद्दों, कानूनी सलाह और कानूनी अपडेट्स के बारे में नवाचारिक और महत्वपूर्ण जानकारी मिलेगी। हमारे साथ बने रहें, क्योंकि योगेश महाजन लीगल आपके कानूनी सवालों का सहायक है।